It looks like on the calendar you have about 25 minutes, so you have 21 minutes now.
All right, I might be able to stay a little bit longer if you need me.
All right.
Good morning, Mr. Chair, members of the committee. For the record, my name is Ptak. I am the director of the Arizona Department of Child Safety. I've been asked to come here and present for about 15 minutes on our statutes, our authority, and how we interact with the family court. So here's our statutory authority. You can see our purpose is in 8451. The primary purpose of the department is to protect children, and then we are to do these four things equally: investigate reports of abuse or neglect, assess, promote, and support the safety of a child, work cooperatively with law enforcement, and coordinate services to achieve and maintain permanency on behalf of the child, strengthen the family, and provide prevention, intervention, and treatment services without compromising child safety. I also have, I've listed here how we're able to take temporary custody of a child. We can take temporary custody of a child one of three ways. The first way is through an order of the court. The second is exigent circumstances, which means the child is unsafe right now, and if I don't act in the time it takes me to get in front of a court, the child will be seriously harmed, or the child's parents or guardian can consent to us taking custody. I've cited here to our initial safety assessment and investment protocol. So this talks about that we have to have a safety assessment guide. It's in statute. I'm going to get into what that looks like and how we use it. And then we also here in 8-809.01, we have parents and guardians' rights. So parents have the right to be informed of the purpose of the investigation. They have the right to refuse to cooperate with an investigation. They can deny us entry if they choose, unless a court order grants us permission. And they also have the right to seek advice from an attorney or have an attorney present. So this is dependency case jurisdiction. So juvenile court, which is not family court, they are two separate things, has exclusive original jurisdiction over petitions to take temporary custody of the child and to terminate the parent-child relationship. Family court has jurisdiction over things like marriage, custody, divorce. DCS can investigate when ordered by the family court if the allegations rise to the level of abuse or neglect. We also will provide evidence to family court for investigation. So for example, if we are investigating, we find one parent is safe, so we are not going to take custody of the child, but that parent wants to use that information in family court, the family court can either order or subpoena the records, they can order the caseworker to show up, and so we can do that. So our case process, it starts at the hotline. All cases of abuse or neglect have to start at the hotline. So a call is made, or mandatory reporters can use an online reporting system. We receive about 160,000 calls every year to our hotline. About half allege abuse or neglect. So half are calling and saying, who's my case manager, where's your office, those kind of things. The other half, about half, meet statutory criteria. So in order to meet statutory criteria, the allegation of abuse or neglect has to be against a parent, guardian, or custodian. We don't take reports on teachers or neighbors or child on child, unless the allegation is the parent is failing to protect from that. It must be against a child victim. The child has to be present or a resident of Arizona, and the alleged abuse has to constitute abuse or neglect. So it has to meet the statutory definition of that. That requires either an allegation of harm if it's physical abuse, or a substantial risk of harm if it's neglect.
Excuse me, to that point,
Mm-hmm.
I noticed here, neglect must allege a substantial risk or harm.
Yes.
Would that include a parent driving drunk or high with the child in the vehicle?
Mr. Chair, yes.
Okay. Okay, thank you.
The example I like to give that I think is helpful, if I call the hotline and I say, my neighbor smokes pot all day long, he has little kids, right? There's no allegation of harm to the child. If I call and say, my neighbor smokes pot, he has little kids, the kids are in diapers in the front yard, they're unsupervised, then there's a risk of harm to the child, right? And that's when DCS gets involved.
Okay, now you've confused me a little bit.
Sure.
So you're saying that if a child, I mean, the Surgeon General says smoking cigarettes is bad for you and you shouldn't have secondhand smoke.
Sure.
Okay, to what, how far do we go down the rabbit trail of exposure by an adult
Sure.
to a child? Frankly, you have a household that's filled with pot smoke, with all the empirical evidence that says that is bad for the childhood's brain development. I mean, where do we,
Sure.
where are we going here with that?
Mr. Chair, I gave that, maybe that wasn't the right example. Let's say, right.
No, maybe it was the right example.
Sure,
We'll have to look at
sure.
that.
In my brain, the child's not being exposed to the smoke. Maybe they're doing gummies, right? Something like that. So the child's not exposed. Like if they say and the child's in the room while they're smoking, then there's a risk to the harm, right?
Okay.
So there has to be a tie to and the child's unsafe.
Okay.
Okay.
Fair
Is
enough.
that better?
Fair
All
enough.
right. Sorry.
I know you were going after the dirty diapers and no food in the house
I
thing.
was going
Okay,
after that.
got it.
Okay.
Chair, to that point,
Yes, Senator.
thank you. Thank you very much for your information. When you talk about there being not a direct risk, if the person popping gummies, you don't know if those gummies are laid out on a table and the child could very well see, wow, gummy bears.
Yes.
You know, how is that not a risk?
So, Mr. Chair and Senator Hatoffoli, the point I'm trying to make is that there has to be a tie to it. So if they say the gummies are out, the kids have access to them. And the hotline, if any of you want to come see the hotline, you should. You can sit in, you can listen to a call of how they take them. It's a script, so they're going to ask those kind of questions, right? They're going to say, does the child have access to them? Are they out? Is there a safe caregiver? Maybe grandma is in the home too, and grandma watches the kids while they're, doing their stuff, right? So I gave a very simplified example, but the hotline's going to ask those kind of questions and draw some of those things out.
One more question, please.
Please, go ahead.
Thank you. Thank you very much for that information. And I know things can change with each situation. I understand that. But statutorily, you stated that there is a definition for physical abuse and neglect. I would be very curious as to know what that definition is and how that relates to the threshold of harm, which normally is the jargon presented when a child may be in danger or if there is no response or reason or justification for investigation.
Sure. So, Mr. Chair and Senator Hatoffoli, so the definitions are in 8201, abuse, and I've worked for DCS for a long time. I don't have them perfectly memorized, but physical abuse has to be an act by a parent or caregiver plus an injury in kind of general terms. That's physical abuse. Sexual abuse is something different. And then we have neglect. And neglect, there's a lot of categories under neglect. The general category under neglect says the unwillingness or inability of a parent, guardian, or custodian to provide the child with things like supervision, medical care, food, those kind of things, if it causes a substantial risk of harm to the child. And then there's some other things like a substance-exposed newborn counts. There's things like if you're making dangerous drugs in the home. Like there's a couple other categories underneath it that I don't have all of them memorized, but they're all in 8201.
Thank you.
Okay, so these are the numbers I talked about, just so you can see them. So like the tan line is not alleging abuse or neglect. Green is alleging abuse or neglect, but it doesn't meet report criteria for one of the reasons I listed. And then the orange at the bottom is it meets report criteria, and we're going to investigate those. So you can see we investigate between 2,000, 3,000, 4,000 cases a month. You can see it's cyclical. So April is Child Abuse Prevention Month. Our reports go way up. The summer, school is out. Our reports go down.
So this is a call volume report.
This is our call volume.
Okay.
Yep. This is total new and closed reports. You all should keep a very close eye on this because some of you probably remember we had the backlog of uninvestigated cases that at one point was 36,000 uninvestigated cases. You can see now it's about 7,200 in August, and that is about where we should be based on the number of staff we have. That's the amount of work we can get done in a month. So we try to keep it right between 7,000 and 8,000. You should keep an eye on these numbers because green is closed, orange is open. If for month over month the orange goes higher than the green, then you need to ask me what we're doing to make sure we're not getting back into having too many opened cases. So
if we
yeah.
could we go back to, just for a moment, defining harm? Is it a physical injury? Is it a psychological injury? I mean, we got a lot of kids out there that are now being reported having PTSD
okay.
because of what they've been subjected to, not only physically, but psychologically. Can you help me with that a little bit?
Sure. So, Mr. Chair, emotional abuse is a separate category. And
enough.
you're working my recollection right now. So
Yeah,
that
I guess what I'm trying to get to is,
It-
do we have a unified definition of harm?
So under the neglect definition, it just says substantial risk of harm. It's not there. Emotional abuse is something that's separate and has to be defined by, or it has to be diagnosed by a medical professional.
Okay.
So those are two separate things.
All right.
Okay. Okay, so contact with our family. So all of our investigators have to be trained in forensic interviewing and the process and protocols. The training must include evidence-informed safety assessment model, which I'm going to get into. That's how we make our safety and removal decisions. The duty to protect the legal and due process rights of the children and the families. They have to be trained on a child's rights as a crime victim. We have a whole victims' rights unit of children who are victim of crime where we help them through that. And then it has to have a checklist or other mechanism to assess them and giving consideration to the relevant factors. So that's what I'm going to talk about.
Excuse me.
Yep.
So, tell me a little bit about your investigators being trained in forensic interviewing. There's that word that pops up again, forensically informed. Are you talking about classic law enforcement forensic instruction?
Yes, Mr. Chair.
All right, so
Yes.
this is the kind of stuff that a criminal investigator like myself would have gone through.
Mr. Chair, yes.
All right, thank you.
Okay. And then we also have our Office of Child Welfare Investigations. So they have to either investigate or touch any case that alleges criminal conduct, which is, if true, it's felony child abuse, any type of sex abuse. So they are a specialized unit that has even additional training. They work specifically and do joint investigations with law enforcement to make sure that as we're doing our piece, if there's a criminal component to it, that we're not impacting the criminal case, and both are able to move forward. We also do it because it's traumatizing for children to be interviewed about their abuse, and we don't want to have to interview them. We interview them, then the police interview them, then the hospital interviews them, right? We take them to child help. We do it all kind of at once.
Excuse me, let me go back to the forensic interviewing instruction. Who does that?
Mr. Chair, I would have to ask. I know they do it in their core curriculum training. So we run it, but I don't know who designed it. I would have to find out.
No, let me reframe the question. Is that done out of the School of Social Work at ASU? Is it done by a post-certified instructor? I'm looking for
Yeah.
who is training these people, because that's going to, I think, reveal a potential bias. That's kind of where I was going with
Sure.
that.
Mr. Chair, I don't know that off the top of my head. I'm going to have to get you
All
that
right, if
answer.
you would, I'd like to find that out.
Mr. Chair, and I have kind of a follow-up or to that point. How long is the training?
Mr. Chair and Representative Keshel, the training is 22 weeks. So they're in the classroom, I believe, for either 4 to 8 weeks, and then they go out into the field and they're trained with, like, they have a supervisor who assists them. So they don't take on a full caseload for 22 weeks.
Okay, so I'm sorry, Mr. Chair. So to that point, the in-classroom training is 4 to 8 weeks. Where is that 4-week discrepancy coming from? And then the rest of the training is just in the field, kind of as an apprentice to a caseworker? How does, I guess I need more clarity.
Sure. Mr. Chair and Representative Keshel, I'm not remembering off the top of my head. I believe it's 4 weeks in the classroom. And so they're doing things like we're talking about the laws, how to show up in court, how to interview a child, all the kind of social worky type things. And then an apprenticeship is a good way to describe it. So you're shadowing under somebody in the office. So you're.
Okay, and one more, Mr. Chair, sorry. When they're learning laws, are they talking at all in this training about constitutional rights of parents and kids?
Mr. Chair and Representative Keshel, yes, they are. And our Attorney General's office also does a training for them on those as well.
All right, ladies and gentlemen, we can't have that, okay? I've been pretty tolerant of applause, but this is about fact-finding. We're trying to be neutral collectors of information. So please, let's control ourselves. If you want to get excited, go out in the plaza, okay? I'm a little distressed over the closed reports piece.
Okay.
A 10-year-old young lady by the name of Rebecca. Died on July 30th after 12 reports to the hotline. So when I see a graph that says closed reports, with all due respect, man, that doesn't tell me squat. I would like to know, and maybe you can't answer this question, and it's fair if you can't, how many of those 12 reports were closed? Or did all 12 remain open? And
Mr. Chair, are you asking?
like I said, don't guess.
No, I'm not guessing.
I'm fine with an answer if you need to go back and research it.
Sure. Mr. Chair, are you asking at the time of her death, how many were open or closed? Or just
So
in
there are
general?
12 hotline reports concerning Rebecca. How many were closed? How many remained open until the time of her death?
Mr. Chair, there was one open at the time of her death, and it was
So-
the final one we had received.
Okay, so there were 11 that were called and closed.
Mr. Chair, yes, and yes.
Okay. I didn't ask the question to make you look bad.
Sure.
I'm trying to understand internally the process of closing cases. If it's a staffing issue, if it's a, hey, we're getting near the end of the month, we got to close out reports so that we meet a number. I'd like to think that these are legitimate investigations before cases were closed or reports were closed. But Rebecca's case is disturbing beyond description. And I'd like to know how many other cases are there like this that we've got multiple reports that revolve around the same child that are either open or have been closed without taking action. Now that's a huge question, and frankly, I don't think I'm going to have you answer it here.
Okay.
As you probably already know, DCS is about to be audited by the State Auditor General at some point in the not too distant future. That'll be something that I am going to ask the Auditor General to take a close look at, just so that you've got forewarning, okay?
Mr. Chair, would you like me to go through how we respond to events like that and what we've done in response to it?
Hold that
or-
thought for just a second. Did you have it to that point, Representative Keshel?
Mr. Chair, I do. I have a follow-up to you because I have here a list in my hand with Rebecca up top of kids that have died in DCS custody. And I guess because we need to work together. There are, what I've learned is especially between the family courts and DCS, I've talked to Chris about this, there is some of the DCS caseworkers going, oh, family court, I'm not touching that. That's a problem because there are kids that are really in danger. And one dead kiddo is one too many. And this is happening because of both DCS and family courts. So I guess how do we balance, because I have a couple of dads I've met here today that are going to talk about being falsely accused. So the ex-spouse is throwing false accusations at these people sometimes, which I know you guys see. I will give you the benefit of the doubt with that. I know that happens. That some of these co-parents, if you want to call them that, have learned how to use the system to continue to abuse or retaliate by false allegations. Is there anything we can do with you guys to help kind of close that gap?
So I think, Mr. Chair and Representative Keshel, I'll talk a little bit about how we respond to cases where a child is killed and we had history, because it's going to answer your question. So it's easy for me to look at the case and say, well, I have a question here, I have a question here, right? I mean, there are things in the case that I look at, and I am probably having this similar reaction to what you are. But I need to understand why staff made the decisions that they did, because it could be, was it management saying you need to close cases quickly because we have to, right? Is it that is influencing behavior? Is it we have a tool at the hotline that I'll talk about, how we screen cases in and how we screen them out? Did we mess with the tool and it did something weird? You know what I mean? Like, I need to understand why staff made decisions that they did. Was it that they know the family and they knew the dad and they were like, we know that, you know what I mean? Like, I don't know the answers to those today. So we do, we have a multidisciplinary team. They involve members of the public. It has law enforcement on it. It has a pediatrician. It has a child's attorney. And it has DCS staff. And what we do is we present to them, here are things in the case that seem odd to us. I'll say they seem odd. They've listened to every hotline call, screened in or out. They have reviewed the hard paper file, and they're going to present this week to the team. Here's where we have questions, and how would you advise us to move forward on this? So we're getting outside perspective on it. We use a third-party contractor to help us do this. And then we debrief the staff, and we say to staff, we're not HR, we're not your boss, we're not here to get you in trouble, but I need to understand how you made this decision, because that's how we make change, right? If it's a policy, they say, well, I followed the policy. The policy told me to do this. Okay, then we change the policy. But if they say, well, the policy is fine, but you all told us we have to close our cases and we felt pressure, then that's what, you know what I mean? That's what we change.
It's a management thing.
I don't want to point and say, fix this, if that's not going to solve it, right?
No, fair enough. So I'm aware that you have a 10:30 hard stop.
I can stay until 11,
Okay, well, hopefully.
but then I have to go.
How about we wrap this up in
You want me
like
to
the
start
next
talking
7
quickly?
minutes?
Okay. I'm a fast
'Cause
talker, but I'm not that.
You might have
I'm not that
noticed
fast.
there's a gaggle of people behind you.
I see that, yes.
That are all here to speak.
Okay.
So.
So I'm going to talk about our safety decision-making model, because it sounds like this is something that you all are having questions about. How do we make safety decisions? Okay, so we have a tool. The tool is to make the right decision for the family in front of us, not using influences, outside influences, some of the stuff I've said. The purpose is to identify if children are unsafe, right? Are they safe? Are they unsafe? Determine who they're unsafe, figure out how to protect them if they are, establish safety plans, and then figure out how we make sure it doesn't happen again. So when I go out, the field goes out to a family, we've received a hotline report, we have the allegations, they should be looking at all of the history with the family we've had. They're going to make a present or impending danger assessment. So present danger means this child is unsafe right now, and I have to act, or the child will be harmed. Okay, so that is present danger. There are 19 present danger conditions. I have them if you want me to go over them, but they're clearly defined. They are immediate. It has to be happening right now. I have to be able to see it. It's not a gut feeling. I have to see it. And it has to be significant to the child. So those are generally what we look for present danger. Most of our cases are impending danger. So the child is safe right now, but we're concerned they're going to be unsafe in the future. So we have 16 impending danger descriptors, which I also have. It requires the field to do a thorough collection of information regarding caregiver function and protective capacities. So when we talk about parental protective capacities, that's emotional, cognitive, and behavioral. Are they able to protect the child? There are 6 domains of family functioning that I can go into if you want me to, but we have all this. And then there are 5 safety threshold criteria. So if I go into the home and I see something, I see dad is smoking pot all the time and the kids around. Okay, we'll use that example. It has to be something I can see. It's observable. I can see the whatever out. The child has to be vulnerable. So if the child's, not in that example, but if the child's 16 versus 3, right, we're going to have to behave differently on how to protect the child. It has to be unmanaged. It has to have a severe effect to the child, and the harm has to be imminent. So it has to be reoccurring. It's going to happen again. So that's when you have a child who's unsafe, if all of those things are met. So once you have a child who's unsafe, you have to safety plan. Removal is the last option. So these are the order we go in. So can the threatening person leave the home? Can the protective parent and child leave the home? Can a responsible adult help? Maybe the issue is the parents go on a bender every weekend and get really drunk and the kid's little. Can the kid go to grandma's house on the weekend? Then we don't have to intervene. You know what I mean? Can we put in some sort of help for the family where the department doesn't have to get involved? If we decide none of those are going to work to keep the child safe, out-of-home care is necessary, we get a court order to remove the child. The worker doesn't make that decision alone. They have to staff it with their supervisor. The judge will reaffirm or modify placement decisions. Our placement preference is in this order with kin, so family first. If that doesn't work, we want a community foster home. We always try to keep the siblings together whenever possible. Next is congregate care, which is not a preferred option, and then residential facility would be like a behavioral health treatment facility if the child needs that level of care and is ordered by the court. 77% of our kids are in a family-like setting, whether in a foster home, community foster home, or kinship placement. In almost every case, last time I checked, I think it was around 94%, the initial goal is reunification. So this is where our kids are placed. It's what I just said. So about 46% are with kin, so that's somebody who's known to the child. 30% are community foster, and about 20% are in a group home. So case planning, when a child is in out-of-home care, the parents get an attorney. They're assigned an attorney. that services are paid for by DCS, whatever services the court orders. They are aimed at helping the parents make behavioral changes to keep the child safe. It should not be compliance-based. It shouldn't be you took 10 classes, you get your kids back. It should be you've taken the classes and you've shown you can make the behavioral changes to keep the children safe. When we remove the children, we give them conditions for return. So we say if in order to get your children back, you have to have made these changes. We tell them what we need to see in order for the kids to get back home.
I'm sorry, who's making those assessments?
So so it should be done in a team decision-making meeting, which is DCS. They're facilitated not by the caseworker, but by someone who's trained in meeting facilitation. So in practice, it should be in conjunction with the family. The family supports. If grandma's a support, grandma can be there. Their attorneys often participate.
Okay, you said in practice. That sounds like in theory.
In policy, that's who should be there,
Okay,
and it should
policy
be right.
is
It should
theory,
be.
practice is different.
Right. I'm sure you're going to have people who are going to tell you that's not what happens. So I don't want to say in 100% of the cases that's what happens. That's
Okay,
how it should, right? That's how it should happen.
Yeah, I guess the source of my question is, do we have a medical doctor assessing for a psychological issue? Somebody who's not, do we have a mismatch in the people who are doing an evaluation?
So, Mr. Chair, it would depend on what the court orders. We usually, depending on what the allegations are. So if there are no allegations the parent has mental health issues, we shouldn't be ordering that as a service, right?
Okay.
But we may get a court order for a psychological evaluation, which will then help determine what services the parent should participate in. But we would pay for that.
Okay, would it be fair to say that your forensically informed investigators have the opportunity to have a moment of first impression to say, you know what? I guess the question is, do they have the freedom to tell the court, something's not right here? And it's not physical. There's either an emotional issue with one of the parents or a psychological issue with one of the parents, and it's presented in a way that gives rise to concern. And I get policy-wise, you got to walk a really thin line on, because it's not illegal to be a bad parent. It is illegal. It's not illegal. It is questionable for a parent who engages in behaviors that are abusive in any way, shape, and form, whether it's physical, psychological, emotional, the whole gambit. Okay? I just want to know, is there a way for one of your field agents to say, I've got a question about this for the interest of the child? And then the follow-on question on that is, who pays for that?
So, Mr. Chair, emotional functioning of the parent is something that we assess in our family functioning assessment. So it is
Okay.
something that we look into.
Okay.
Some of the safety threshold factors describe that. So like one of them is the child is profoundly fearful of a parent, guardian, or custodian, or somebody who has access to the child. The child can describe the threats. They seem reasonable, believable. They have fear of retribution or retaliation. Some of them have to do with like erratic behavior, those kind of things as relate to the parent. So those are contemplated in our family functioning assessment.
Okay.
Mr. Chair? I have a
Representative
question.
Fink?
Thank you. Thank you for coming. In regards to this case planning, because I have had many different family court cases where DCS has come out, and yes, there is, evidence of abuse, and yet DCS says they're not going to do anything and allows the child to go back to the abusive parent. And so, but here you say you have a case planning process. Where does that fit?
So, Mr. Chair and Representative Fink, This I think is the crux of the issue, right? We don't take custody of a child when there's a safe parent. So I knew you were going to ask me this question, so I looked up the statute. So a dependent child, which means they're in our custody, is defined as there's no parent or guardian willing or capable to care for them. And I think this is where a lot of the questions come up, because we investigate, we say, Mom, you're safe. Dad, we don't believe is safe, but we can't take custody just from Dad, right? That's not a thing we can do. What we can do, and what we've been working with the family courts to do, is to help get our information to the family court, because we've interviewed the kid, we've interviewed the parents, so we may have information that's helpful. Our workers frequently testify in family court about what they observed or what they saw. We provide documents, and we're figuring out a way to get documents quicker, because as we said, that some of these temporary custody hearings are in a couple days. So we've worked with the courts to say, don't ask for the whole case file, right? Because the whole case file could take 1,000 pages and take a month to get you. But if you ask for these 3 or 4 documents, they're going to get you the information you need, and we can do it today. So that's what we're trying to work with the courts on, to make sure that they have the information where we're not able to act, but we have information that's helpful, right?
To that point.
So we've got about 5 minutes left.
Okay.
Go ahead.
I'll go ahead.
Okay. I guess, and I want to let you get through the rest of your,
Okay.
you're going to have to steam through it pretty fast, but I do have a question. So you get federal funding to reunify under Title, I think it's Title 5, or Title 4E and Title 4B. So Congress now recognizes in their findings that reunification with an abusive parent is detrimental to the child. So I'm thinking it sounds like we need to have a policy adjustment at the very least, if not a statutory revision. Can you speak to, just momentarily, how much money comes in to DCS from the federal government for that purpose?
So, Mr. Chair, the money isn't specifically for reunification. So once we've removed a child and they're in out-of-home care, we can use federal funds. It's a match, so we have to have state dollars attached to it for particular things. So sometimes it's services to parents, which is what you're talking about, reunification services to parents. And sometimes it's for the child's placement. Sometimes it's we can use some for administrative costs. We use it for a variety of different things. What the law says is, in order to sever a parent's rights, which means we're not returning the children, certain grounds have to be met. So there are a couple that we can do right away. So kid comes into foster care, we say, you're not getting your kid back. What you did is so bad, you're not getting your kid back. That is few and far between, okay, because they're serious things. Generally, we can only sever parental rights if a child has been in out-of-home care and foster care for a certain amount of time. We have tried to reunify, because that's what the law requires, that we give you services to make you a better parent. You have failed to make the behavioral changes, then we can sever your rights. So if we don't attempt to reunify, then we don't have a ground to sever their rights. And that's federal, that's state, it's everywhere.
Okay. All right. So in the 4 minutes you have left, get to the most important stuff.
Okay.
And I'm sure we'll have an opportunity to review this again.
Yeah, of course. Okay, so I was just going to talk about some of the services we give to the parents. So the juvenile court can order the services. Parents, they don't have to comply, right? We don't make you show up to therapy. The services can include visitation. It almost always includes visitation. It's generally supervised at the beginning. So you'll have somebody watching the parent interact with their child. At some point, if the parent is participating in the services, making the behavioral changes, we can shift to unsupervised. It's often parenting classes, sometimes it's therapy, sometimes it's drug or alcohol counseling. We pay for all of this. Parents can use their own insurance if they want. If they say, I have a therapist through my church who I want to use, we allow that. If not, we're going to pay for it. If the parent is out of state, if the parent is incarcerated, we will still do those services if they're ordered by the court. It depends on what they're incarcerated for, obviously. And then if the child, like the grandma lives in Indiana and we want the child to go live in Indiana, we'll pay for, it's called Interstate Compact for the Placement of Children. We'll pay for the services interstate so they can still have visits and all that kind of stuff. And then I knew we were going to get to this. So we don't have authority to remove from one parent. So we'll say, you have to deal with that through family court.
Okay, I have a question, Mr.
Representative
Chair. So on the money issue, what do your caseworkers make? This is just something I don't know the answer to. I don't think it's very much.
Mr. Chair and Representative Keshel. No, they make about 55 is where they top out. So we've done a couple things to try and incentivize when people leave, because turnover is a problem, and quite frankly, I think that's something we may learn from this Rebecca case, is that you have new case managers coming out, and maybe, they're not as seasoned or well-trained as some other, not well-trained, but, they're not as seasoned as other caseworkers. So we give them a pay increase when ASRS kicks in, because if we don't, then they're actually making less money than they were to do the same job. Their paycheck is lower. We give them a pay increase at 18 months, because that's when we see a lot of people leave. But they top out at about $55,000.
Okay. And I just have one more, Mr. Chair. I could ask you questions all day. I have so many. But one of my questions, because you vaguely touched on your experts that you use. Are there any experts that are being utilized, I call them experts very lightly, that are being utilized in both the juvenile courts and the family courts, or is that a whole separate entity? Is there anybody that goes back and forth?
Mr. Chair and Representative Keshel. That's a good question. So I know some of them have court contracts, so they could. I don't know. I'll find out. Okay, and I'll get you more information about the training too. I'll make sure we get you the right stuff.
That's it. Thank you very much. I appreciate it.
All right.
I know you've got to get going. I'm sure that this topic is not going to go away. We'll have an opportunity to talk more.